Hold on. Okay, good morning, everyone. My name is Ellen Riedel. I'm a staff attorney with Maryland Volunteer Lawyers Service, and I'm here with Deborah Devan, who's going to be talking to us today about district court discovery. If you can't hear me, please send me a chat. We're doing the audio by phone, so I just want to make sure that everyone can hear me. And if you're having any trouble seeing the screens, please let me know as well. We have a couple more attendees who are about to sign on, or we're waiting to sign on, so we may get a little bit of a later start, just a couple of minutes, but we wanted to sign on to let you know we're here, and we'll just kind of chat a little bit before we get started. And I also wanted to go through some of these screens here to follow us on social media. So we are on Facebook, we're on all of these social media accounts, we're on Twitter. So follow us for news about trainings and events and all sorts of good stuff like that. And then just to, hopefully, let me get the screen going here. Okay. And then you can see here the pro bono portal. If you guys haven't looked at it yet, you should go to our website and take a look at it. It lists all of the cases that we have available in real time. So as soon as we accept a case from a client to try and place with a volunteer attorney, it goes up on the portal. And as soon as someone takes that case, it comes down. So you can see at any time what cases we have, and you can actually click on a case if you're interested in it, and it sends us a message. So it's a really great, efficient, and up-to-date way to see what's going on and see what we have available. And let me see here. So the last slide I'm going to go through. So this is actually what the pro bono portal looks like. And just to explain a little bit, if you look across the top, the different colors are actually different case types. So you can click on those and you can sort by case type. And then you can also search on the drop-down menu by county, so you can search in the county that you are or a county that you want to work in. So it's a really great way to find a case. And then, we want to get started. Debbie?
Okay, thank you. Just a couple of points before I start into the materials. First, why do I take cases for MVLS? I'm actually retired. I practiced law for 45 years. I guess I'm still practicing law to a certain extent, but only for MVLS. I take a case because, first of all, I think it helps me get to know people that I might not otherwise know. And I think that's an important thing in life. The clients that you deal with, of course, come in all different types, as all clients do, but most of the clients I find are people who have limited means. They struggle every day to make those means stretch to fit the needs of life, and I learn a lot from them. So that's the first reason I think I take cases. The second reason is because there's such a big need. I will say from my personal experience of the cases I accept, and I probably accepted over 100 cases last year, I find that about 80%, perhaps more of them, end up with no liability whatsoever. Now, that's a pretty strong thing to say, because if you don't come in and help these clients, they're going to get judgments entered against them because, for the most part, they don't know how to defend themselves. Whereas when I come in, 80% of them walk away with no judgment against them. And that's a pretty compelling reason. There's another 20% that, for one reason or another, work out settlements, they get reductions in the debt. A number of them, I work with the plaintiff's attorneys, and we find that there were payments that weren't credited, there were questionable items. So the second reason to take a case is because it matters. The third reason, of course, to take a case is because we're all members of the bar. We all have the privilege of having a license, and the Court of Appeals urges us to take cases, so that's a pretty good reason to take cases as well. Let me move now to the materials. So I think that you can see the little outline I put together for today's discussion. I'm going to start basic, and then I'm going to go more complicated because I think we have different levels of attendees. First of all, when you're in the district court, you know that there are separate rules of civil procedure from the district court. They are different from the circuit court. They are found in, of course, the Maryland rules. They are the Rule 3 - whatever series of rules. So with discovery, we have our own general provisions concerning discovery, which are in Rule 3-401. I put on the screen only those things that I think were relevant, but of course, everyone needs to read all the rules. The first thing I'll say from the standpoint of practice is that unfortunately, with MDLS cases, there is often no discovery permitted. No discovery permitted. So the rules say that you get the right to send interrogatories, but they have to be sent timely. I'll talk about timeliness in a minute. As far as any other type of discovery, you need to have a stipulation with opposing counsel in order to obtain that type of discovery. You can do depositions upon stipulation and depositions on written questions, but by and large, the only type of discovery you truly get in a district court case is these interrogatories. My practice shows me that what plaintiffs do is they file the interrogatories with the complaint. It is attached to the back of the complaint. Most of the clients that I deal with cannot even fathom the first page of the complaint, which supposedly is in easily understandable English. The first page tells them that if they have a defense, they need to tear off the bottom and write the defense in and mail it back to the court. In my experience, the clients that I've worked with do not understand that. There's different reasons for that. It is not really in legalese. However, when a non-lawyer looks at that paper, the first thing they see is a caption, and they know that a caption means court, and in my experience, they don't read any further. So that most clients do not get to the point of even reading the bottom part of the page, which says if you have a defense, fill in the defense, tear it off, and send it within 15 days of service of the complaint upon you. So if they have not done that, then what happens is there will be a hearing of some type. If the complaint is filed on an affidavit basis, which the cases that I deal with are almost always affidavit basis, and just to sidestep for a moment, what is an affidavit case? The plaintiffs fill out the bottom of the complaint form and have it signed by an individual who states that they have personal knowledge of all of the facts contained in the complaint and that they ask the court to enter judgment immediately upon the time running for the filing of a defense. In practice, there is a hearing called an affidavit judgment hearing, and at that hearing, the judge will allow individuals to file defenses if they are meritorious. So if your client understood the directions on the original complaint, they would fill in their defense, they would tear it off, and they'd mail it to the clerk. If they did not, then they get assigned to an MDLS attorney, or they meet us at a clinic, and we do the defense, but it has to be a meritorious defense. So the client has to tell you that I don't think I agree with the fact that I owe this money. If it's a meritorious defense, the district court judges will allow the case to proceed to trial. Again, most district court judges are fairly accommodating with a meritorious defense if it's written by an attorney. However, defenses like, I lost my job and didn't have the money to pay, or I had to go into the hospital, or something along those lines is not, of course, a meritorious defense, and the district court judges are pretty strict about not allowing those defenses to proceed. And again, many of our clients think that that is a good defense. The courts call that an excuse, not a defense, and excuses do not win the right to a trial. So to move on, let's assume that the defense is filed on time, or it's a meritorious defense and is accepted late, and the court then sets the matter in for trial. What do you do about discovery? Well, that is why I have put the rules in here. So Rule 3-421, which I think is on the next page. Okay, it says availability, number, and time for filing. Availability is the first sentence. Any party may serve written interrogatories directed to the other party. And unless the court otherwise, it's only one set of interrogatories and only 15 in number. However, the next sentence on your screen is what will kill you most of the time. Well, truly the second sentence. It says the plaintiff may serve interrogatories no later than 10 days after the date on which the clerk mails the notice required by Rule 3-307D. I put in parentheses that notice is the notice that the clerk must send out when a meritorious defense is filed, a notice of intention to defend, when it's either filed within the first 15 days or filed after the court allows it, finding it to be meritorious. So the next step is that the clerk sends out a notice to the plaintiff with a very, very short summary of what was stated in the notice of intention to defend. Note that it is a short summary. So the plaintiff has the right to file interrogatories within 10 days after the date the clerk mails that notice, and it is a mailing rule. So if you don't want to have a client answering interrogatories that they don't have to answer, you would look at the mailing date. By the way, you, representing a defendant, do not get a copy of that notice that the clerk mails after a NOID is accepted. By the way, NOID is N-O-I-D, Notice of Intention to Defend. That's just my shorthand. You can go to the online docket and you can see the date that the clerk indicates that it mailed the notice to the plaintiff. So if the interrogatories are not served within 10 days after that date, you don't have to answer them. Although I would recommend that you file a response which sets that out so that you're not deemed to be in default in the response. And then there is Part D, which says the defendant may serve interrogatories no later than 10 days after the time for filing a notice of intention to defend. Now, what does that mean? Does that mean after the court accepts a defense if you file it and it's deemed to be a meritorious defense? The cases say no. So, practically speaking, if you accept an MVLS case, you may be in the situation where you are not able to timely propound interrogatories. And remember, basically, that is the only type of discovery you're automatically entitled to. What do? I will send interrogatories anyway, at least standard interrogatories asking for very basic things. My success rate in getting those responded to is probably less than 20%, but at least it will open communications most of the time, and you'll get a call from the plaintiff's lawyer saying, I'm not going to answer these, they weren't timely. And then you can ask for some basics to be sent to you, which I find most plaintiffs' attorneys will do. The basics, sometimes we don't have a complete copy of the complaint. Sometimes we don't have any copy of the complaint. I always ask for an emailed copy of the entire complaint, because even if I have what the client has given to me, I find that the staples may not have held all the papers together and you may be missing papers. You never know. So I always ask that that be sent, and I've not had a problem with that. I also generally ask, after I review that, for other things that may be relevant to what has to be proven at trial. And again, a nice request is usually met with the papers being supplied. So what do? If you get interrogatories from the plaintiff? Again, the response. Note the response date. We all know 15 days after service of the interrogatories, that's a no-brainer. But the second part is within 5 days after the date on which that party's notice of intention to defend is required. So what does that mean? Well, again, if you get the interrogatory served with the complaint, then you have your normal 15 days. It's the 15 days to file your notice of intention to defend. It's 15 days to file your response. In my experience, we don't get the cases that quickly. So in district court, you can expect that many times you will already be late. Again, it's a practical thing. You contact the plaintiff's attorney and say, I just got into the case. A, were there any interrogatories? Because sometimes there are and you don't know about it. And B, send me a copy in a Word format so that it is easier for me to comply with the rule, which requires you to restate the question. And C, give me 15 days from the date you send that to me, and I will get you the responses. So next is you work with the client to get the responses done. Again, a couple of practice tips. I mean, we all know how to answer interrogatories. You take the form, you reprint the question, and then you create spaces. When I say you reprint the question, that's assuming that you got it in Word format from plaintiff. And then in the space after each question, you put in your response. I have included with the papers today a response to interrogatories that I use in district court. The main reason for sending it to you is my general objections that I put together. I don't think these are anything particularly brilliant, but I like to use these general objections whenever I respond to interrogatories. And then, I go on with my responses and show the normal format.
I'm sorry to interrupt, Debbie.
Sure.
I think the response to interrogatories, I don't know if I got that up on the handouts that are already available to you guys. So if that's not, if you click on handouts in the webinar screen and you don't see that, we will send that out to all the attendees afterwards if you can't see it. So we'll send out all of the handouts again to all the attendees. I just wanted to make sure that if you can't see it, you will get it, and we can make sure of that. Okay. Again, practice tips. Usually, I will do interrogatory responses with my client by telephone, and of course that means I'm writing them, which is nothing different from general practice, but I usually make a note of that. Secondly, because I am doing them on the telephone, what I almost always do is get them all typed up, send them to the client for review, and at the same time, I send a draft to opposing counsel just because most of our clients have to do things by mail. Some of them do have email accounts, but I find that most of them don't have a printer, or if they have a printer, most of the time they're out of printer ink, because as we all know, printer ink costs a fortune.
So I will send a draft to opposing counsel with a note that this is what I believe the final will look like, reserve the right to make any changes, but that the originals are out for signature by the client. And of course, we all know that when we get these signed ones back, we do a certificate of service that you served it, and with the court, you file a notice of service of answers to interrogatories, which again is in the form that you either have or you'll get later. All right, so that is interrogatories. And by the way, I think, Ellen, did you say there was ability of people to pose questions?
Yes.
Okay, so I don't know how to do that. Ellen, do you want to tell them how to do it?
So if you go into the control panel for the webinar, there should be a chat bar. You can click on that. It's going to expand, and you can type in a message and send it out, and we should be able to see it. So if anybody has questions about interrogatories or what to do with them, you can type in your questions. As we go along, if you have questions, go ahead and send them by chat to us, and we should be able to see that, and we can always stop and answer questions as we go, or we may stop at the end of each section and kind of go through those questions. So please feel free to send us questions if you have them.
Okay, so moving on to discovery. As I said, lots of times you really don't effectively get any discovery in a case. So what do you do? Well, I use subpoenas as a way of getting around the fact that you don't get any discovery. There is a subpoena rule, there is a subpoena form. The rule is 3.5.10, I think it's on the next page. The official form for subpoena, this is interesting. It's, I got the form number up there. I think, yes, DC, sometimes you have to put in a CV before you put 04, but I will tell you that recently when they changed the online search engine for the rules, which by the way, I have not found to be a particularly good change, you cannot get this document. If you put in DC-CV-004, you will get nothing. What I've done is I go actually through Google and put, Maryland District Court Form DC-004, and I can get a downloadable version. I don't know exactly why it's not available from the court website, and I think everyone knows the court website. I did put it in here somewhere. It's, there's two different ways to get to it. It's maryland.gov, or you can go with the official one. So it's mdcourts.gov, or you can go courts.state-maryland-us. Either way, gets you there. So again, I go online to Google, and I Google this form, and then you can get a downloadable form, and once you download it, you are in business. I think the one that I attached is partially filled in. It isn't always so easy to figure out what they want on this form, especially when you get down to special messages. A couple of things about subpoenas. You have to serve the subpoena within 60 days after the issue date. You also need to have it signed by the clerk of the court. There's two different ways. I usually go ahead and fill mine in and then take it to the clerk to sign it. That way, if you mess something up, you got a final version before the clerk signs it. Some clerks don't like that, and they will only give you one that they have signed in blank, and then I always ask for a couple. With a special message, I usually do not put anything in there, and I've never figured out exactly what that's for. So if anyone else uses the special message and knows what it's for, I'd be glad to find out what that is for. So the subpoena, of course, can be to testify, or it can be to produce documents. Sometimes I would check both. Many times I just ask to produce documents, because what I really want is to get the documents, to have them, and then decide if I need someone to introduce them in trial. Lots of times, if you have the documents, you can deal with opposing counsel and just go through those documents and work something out. And by the way, that is always my goal, in the district court, if I don't have complete defense where the case gets dismissed, I always work very hard to work out a settlement. And the settlement is always a practical settlement from my point of view. That is, what is the true amount of the liability and what can my client afford? It's a little bit of a digression, but I always get information from my client on their income. I think most people understand that if the client's income is some sort of government payment, whether that is a Social Security payment, whether for age or for disability, or if the payment is a pension, not that that's really government, but it is a pension. Maryland exempts that from attachment on judgment. So it's always important to get that information. The second thing I want to know is what the client's wages are take home. I usually ask the clients to give me copies of their pay stubs. Again, you're usually dealing with the mail because people don't have the ability to scan and email, so it takes a little bit longer. You can ask them to read it to you, but I always try to get a copy in my hand. And then I look at the Maryland exemption amounts. If they get paid every week, they get to keep around $230 every week take home that is not subject to any type of garnishment. Other than that, 25% is subject to garnishment. So I always try to get that information, and then I go back and try to craft a settlement based on that. If the income is entirely exempt from garnishment, I usually provide that information in an affidavit letter, a letter that I sign and say, I have personal knowledge of this information. And what I put in there is ownership of real estate. I will check that online. Vehicle ownership, I rely on the client to tell me about that. And I have the pay stubs, or most importantly, if it's Medicare or pension, I actually get the Medicare, not Medicare, the Social Security award letter, and I get the pension. Usually you get some sort of benefit summary every year, and I get that. And I'll send a letter and say, please dismiss this case based on either the fact that the client is judgment-proof or hardship. Basically, it's the same. I would say 80% of the counsel I deal with will do that because their clients don't have a great deal of interest in getting judgments that will never be paid. There are some debt collection firms that are from out of state that I've been dealing with that will never, ever do that. They say, we want a judgment, and then we're going to try to get some payments voluntarily. I think they prey on the fears of many of our clients that something bad will happen if they don't reach a settlement to make some payments. I've got a case now with an 83-year-old woman who gets only Social Security and a pension of $180 a month. I've proven all that. The plaintiff's attorney required me to get a doctor's letter from her doctor that she couldn't work. She's 83 years old. On and on and on and on and on. And still, this plaintiff at Citibank will not agree to dismiss the case based on hardship. They are still insisting that we reach some sort of a settlement where they're going to go to judgment, and then they're going to take supplementary proceedings. Again, I've threatened them saying you can't take supplementary proceedings because it's not in good faith. I've given you everything voluntarily. But so that's my digression for the moment. To go back to the subpoena form, the most important part of the subpoena, I think, is who it goes to. And again, I've used one which is custodian of records. I used Wakefield. I'm not picking on them, but I think that a lot of landlords are under the Maryland management rubric. There's Wakefield. There's a lot of others. You serve it on Maryland management because that is the custodian of records, and then you serve it on the resident agent. Or if you know the name of an officer, you can serve it on an officer. The next thing that I've given you by way of a handout is an attachment to a subpoena. I decided to leave the landlords alone for a moment for this, and show you what I do with bail bonds. The bail bond industry is a highly regulated industry. However, the actual practice of the bail bondsman, in my experience, is they kind of ignore what regulations exist that apply to their business. So I have put together a form of subpoena that I use for bail bonds, which is the attachment, and it goes through things that I know that they are required to keep under the regulatory statute and which many of them don't keep. Why do I do this? I think I do it more to force some sort of a reasonable settlement because, frankly, while the regulations are there and they say a bail bond company shall, it isn't clear what the penalty is if they do not do it. So just to go through the general things, I asked for the business records evidencing the appointment by a surety insurer. So as we know, bail bonds are insurance products. They are regulated under the Maryland Insurance Code. I put a reference to it down below. And a bail bondsman can only sell a bail bond if they have an appointment by an insurance company. So I asked for that. I suspect they probably all have it, but most of them can't produce it. Then I asked for business records evidencing the name of the bail bondsman who sold the bond. The person who actually sells the bond is required by Maryland law to be licensed, and therefore I asked for the name of that person because many times they are not licensed. Again, the third one is directed to the same thing, asking for the licenses for the plaintiff, the bail bond company. A lot of the bail bond companies will do business through DBAs, doing business as, and you know, they use names that I think kind of appeal to the public: discount bail bonds, bargain basement stuff, to try to get people to come to their business thinking that they're getting a lower price. In fact, the price for the bonds is set by statute, and no one gets a better price than anybody else for the exact same bail bond. However, the insurance commissioner does frown upon the use of trade names that signify some sort of a discount. So while the regulations require that any trade name used be registered with the insurance commissioner, I find that that frequently doesn't happen, and I was able to get the insurance commissioner to take action to revoke licenses of a couple of bail bond companies that continuously used DBAs that were not registered with the insurance commissioner. So that's why I asked that. The installment agreement. When bonds are sold, people pay a down payment, which is 10% of the bond premium. That payment is due no matter what, no matter whether the individual has the case dismissed before they even go for a hearing, whether the case is steaded or lost when they actually have trial. You must pay that 10% premium, and I find that many of our clients do not understand that, so I always want to get a copy of the installment agreement, if for no other reason than I can go through it with the client, show them the signature, show them the amount, and show them that whether they understood it or not, they agreed upfront to pay the full deposit, the 10%, and usually that is the amount that is being sued for. Another thing I've asked for here is any other documents that the defendant may have signed. I look for these because limitations is an issue in bail bonds. For the most part, they have the simple seal by the signature, which is not enough under a few Maryland cases to make it into a specialty. Even if it is printed in the body of the bail bond agreement, it'll say something like just signed, sealed, and delivered. Very simple language, and that probably is not enough. So I want to see all of that see if there's been any payments made that might extend the limitations from the date of payment, because again, many of these I am able to dismiss on limitations. I think that's enough for that attachment. Let's talk about some evidence issues, because evidence is always something in the district court that you have to think about. The evidence rules are the same in the district court as in the circuit courts. And it's basically the Rule 5- series of rules. 5-101 says that there are certain exemptions from the general rules of evidence, and one of those exemptions is something to keep in mind in the district court, which is small claim actions under Rule 3-701 and appeals under Rule 7-112. The rules of evidence do not apply in small claim actions in the district court. So most of the district court judges, in my experience, will tell clients that. They will say, okay, your case is under $5,000, so when you go to trial, you can tell me information that might not otherwise be admissible in a court. However, if your case is $5,001 or more, you ought to have an attorney, because the formal rules of evidence apply, and I cannot hear from you unless you comply with the rules of evidence. One of the other things that I just mentioned in my outline, which I think is important, is self-authentication. So I have had some issues with this in the district court, and it's one of the reasons I wanted to talk a little bit more about it. Sometimes I have issued subpoenas to governmental people asking for their records. That particularly would relate to debt buyers who need to be licensed, and it would relate to bail bondsmen who need to be licensed. And now, as of January 1, 2019, it relates to landlords in Baltimore City, where the properties have to be licensed. So in 3 of the most common kinds of cases, you are dealing with situations where they have to be licensed. So usually what I do first is I would contact someone, or in the case of Department of Housing, I go right to the Department of Housing counter in the Department of Housing office in the Baltimore City Executive Administration Building, I think it's called. And I would ask to see files and see what I can find. I do this before I issue a subpoena, because many times the people that work for the particular agency will be helpful to you in helping you find the right thing and helping you know what to actually subpoena. So just to choose an example, with a new landlord-tenant situation, if I'm dealing with a property in Baltimore City where rent is being sought for any time period, January 1, 2019 and later, I stop by the desk, it's right by the district court offices on Fayette Street, and I give them the address and I ask to see if there is a license. Amazingly, many of them are not licensed. Why is that? Well, there is an inspection required. That is really the point of the licensing for landlords. The property has to be inspected by an acceptable inspector, and they're looking for the normal things that you'd be expecting them to look for. Safety is the main issue, health is another issue. So until that is done and the fee is paid, I don't think it's a terribly high fee. I think it's $180 a property a year. Actually, the registration is good for a couple of years, so I think it's $180. But until that's done, the property is not licensed. And if you look at the Baltimore City Code, which is where you will find the licensing requirements in an amendment, they are not permitted to rent the unit to a consumer if it is not licensed. So I take the position, which is backed by the people at the housing department, the attorneys at the housing department, that they cannot sue for rent from a consumer for any period after January 1 when the property was not licensed. I will tell you, I've had some problems educating district court judges on that. And I've got one coming up. Maybe this will be the first time I'll get a judge who will agree with me, but that is the law. So what do? Once you find that it is not licensed, you have the issue of how do you prove a negative? How do you prove there is no license? And that is the, I don't know, I think, did I attach that third form? There is a form certification.
Certificate of custodian?
Certificate of custodian. I think that's one of our handouts.
That's one of the handouts.
Okay, so you can look at their certificate of custodian. It's form DCCV 110. And by the way, I tried to get this online as well through the new court forms, and I was not having any luck. Maybe it was just me. Maybe it should be just DC 110. I typed in the word certification. In any event, this form is your friend if you are dealing with public records. So again, to go back to the housing department, but it would be the same if you're dealing with the insurance commissioner for a bail bond, or you're dealing with the consumer, I can't think of the name of the agency that licenses the debt buyers. Same thing. If they give you records that show license, no license at all, which, again, how do you prove a negative? I usually ask for a letter, which has in it the language on this form that this person is the custodian of the records and so on, and that there is no license for this unit as of a certain date. Make sure you have it as of a certain date. Same thing for the collection, debt buyers registration, and same thing for the bail bondsman. You then can take that form and you can introduce the letter without having a live witness. In the alternative, you can subpoena a live witness, and the housing department, I think, is pretty good. The people there have been very willing to come to court and testify. Insurance commissioner is a little bit harder to get them to come, but I have gotten them to come. So either way, the subpoena to testify at a hearing must be served at least 5 business days before the hearing. So keep that in mind. I usually do the subpoena for the records as soon as I can, and then if I need a witness, I try to do it as soon as I can, but you must do it at least 5 business days before the trial. The rule that I'm quoting is Rule 5902 on self-authentication, certified copies of public records. You can read what the rule says. Again, most of the time, I'm dealing with a negative. There is no license. So you cannot actually get the record because there isn't one. What can I say? There is no record. And all you can get is a statement that they've looked in their database under, you know, whatever you've told them. It's the address, if it's a property in Baltimore City, that they consulted the database as a certain date, that it's their experience that if it is licensed, it's going to be there, that it wasn't there, et cetera, et cetera, et cetera. I'm a little bit more successful with newspapers and periodicals. I can usually get those into evidence, but I always have a problem when I try to get public records into evidence. So that really is my prepared remarks. I plan to talk for 45 minutes with prepared remarks. I don't know whether we have any chat questions at all.
I don't see any.
All right, well, that's my prepared materials. If you have a chat question, if you could send it to us right now, I am prepared to take questions for 15 minutes. Otherwise, I'll send you back to your desks practicing law for the rest of the hour that we allotted for our webinar.
You know, I just wanted to take a minute, one, to thank you, Debbie, for coming and talking about this. This is really something that, for me, I didn't really know a lot about when I started working for MBLS, and it was kind of hard to find people who could help me with that, because there are very few attorneys that are doing defense work in the district court. The vast majority of defendants in the district court are unrepresented, and so we really wanted to try and create help and for attorneys who are doing that defense work, because a lot of them are, legal services or volunteers. So we're really happy you could come and do this presentation today.
I also gave you my email address on the materials. Feel free to email me if you are stuck, and maybe I can help you. I do have cases that I did not include today because it gets to a more complicated presentation, but I do have cases that I can help you with if you need cases. Most of the time the judges don't like the cases very much either, because you've got to bring copies in and then they say we don't have time to read them. So try to stick to the rules, because the judges all, in my experience, know the rules very well.
Yeah. And then the other thing I wanted to just quickly talk about, since we have a little bit of time, is the consumer protection clinic that we do in the district court. Debbie is one of our regular volunteers at this clinic, and when she was talking about the affidavit judgment process, that's actually where this clinic kind of steps in. So we do a weekly clinic, volunteer clinic, every Tuesday morning at the district court for Baltimore City. And we do this clinic on Tuesday morning because there's an affidavit judgment docket every Tuesday morning. So we, myself and usually 2 to 3 volunteer attorneys go, and we select some cases for the defendants who appear for the affidavit judgment docket, and we sit down with them one-on-one and go through their cases to see if they might have a meritorious defense. And we help them enter those defenses, and then the case gets set in for trial, and then we usually try and place those defendants with a volunteer attorney. So it's a really great opportunity. If this is all kind of new to you, it's a really great opportunity to kind of get involved where on a limited scope basis, although if you come to the clinic and you talk to a defendant and you really want to take on the case, you're more than welcome to do that. But it's really a situation where we are there because defendants just either don't understand the process at all or just don't know that they have defenses. And so it's really a way to make an impact, and on a weekly basis, we're there every week. But if you are interested, you can contact me and I can get you signed up for a date to come. If you're nervous about it, what I usually do is pair new volunteers with a regular volunteer, an experienced volunteer like Debbie, so you can kind of see how the consultations go and what we do. It's one of my favorite things that I do at MBLS, because you really do get to make a difference very quickly in someone's case. And I just encourage you to volunteer for that, to come and check it out. And the other thing I just wanted to emphasize, I know, and especially with the subpoenas and the public records, Debbie kind of talked about this, is licensing. It is something that is rampant in district court cases where people are not licensed to do what they're doing. And so that's something in every single case. Anytime there is anything that might need to be licensed, make sure that you check it. And if you're not sure where to go to check it, let me know. Let us know, and we'll help you do that. Okay.
I just wanted to mention too, one of the things that I think that you can learn in the Consumer Protection Clinic is familiarity with all this licensing. So if you don't know and you want to come to the clinic, don't necessarily feel I'm not qualified because I don't know, because we do have, Ellen's always there, or Amy, and sometimes Ellen can't go, and then we do have other attorneys there, some very, very well-known consumer protection type attorneys, and they can help you learn. One of the areas where I think there's a good opportunity to learn is motor vehicles. Motor vehicles are a big, big part of this clinic because first of all, Maryland enacted an increased interest rate in the 1980s for motor vehicles. In the 1980s, in like 81, 82, we had something that historically was called disintermediation, and money was flowing out of savings and loans, so they were paying 17% interest, 15% on their accounts to their depositors to keep the money there. And the car dealers went to the Maryland legislature and said, we need a quick fix because we need to charge more interest. And they got this little provision enacted, which is called closed-end credit law. And of course, like many of these things, it sort of looks like it's a consumer protection thing. It's not. It is the justification for the car dealers to charge, I think it's 24% interest maximum.
Up to 24%.
Up to 24%. Even today, with interest rates very low, the car dealers are routinely charging 24% interest on these vehicles. People will tend to look not at the realities of what they need for transportation, but they'll look at what they'd like, and the car dealers will say, gee, your car payment is, $300 a month, and anybody can afford that, which many of our clients can, many cannot, and they'll sign up for it, and then inevitably something will happen. They default on the payment. The car dealers hold on to that paper, in my experience, and let the interest accrue at 23.99% for a couple of years. By the way, there's a very unfortunate case in Maryland which says that the statute of limitations for what I call dealer paper, the loan you sign when you buy a car, is 4 years, not 3. It's 4 years because the Maryland Court of Appeals said that dealer paper is a sale under the Uniform Commercial Code, Title II, and sales of goods have a 4-year limitation period. The countervailing argument, which was in the dissent, is no, this is really just a security agreement. It is not the sale agreement, it's the security agreement. It ought to be 3 years under Article 9 of the code, but they lost, and so they have a 4-year limitation. Again, the car dealers will take the car, not the dealers, the holders of the paper will take the car back, they'll sell it, they'll get a deficiency, and they'll hold on to it, earning interest at 23.99% for years, and then they sue the hapless individual for $16,000, $18,000, $22,000, and frankly, for many of our clients, the only thing they can do is to file bankruptcy. However, if you're careful in looking at the paperwork, I have found that there are ways to challenge the rights to claim interest if statutory notices were not timely sent. So that's a good thing to know how to do just in general. If you're interested in car loans, come to our clinic and maybe we can get you a car loan case and you can learn some of the ins and outs of those.
Yeah, and so at the clinic, what we're doing is really actually limited in that we are only there that morning to help the defendants figure out if they have a defense, and to help them enter that defense before the court that morning. So it's just the clinic really just touches on that discrete part of the court process. But then anyone that we see at the clinic who needs further help, MVLS will take, if they income qualify, then we will take that case and try and place it with a volunteer. I do find that a lot of volunteers enjoy taking the cases that they consult on, but it's not required. So if you come to the clinic and you consult on a few different cases and you want to try one of them, that's fine. That's wonderful. If there's something that you consult on you're not comfortable doing, then we can place that with another volunteer. But it's really a place that you can kind of test the waters and get out of your comfort zone. So I'd really encourage you to come and try it out. And then I think I just have a couple of one last slide to show everyone with just new events coming up. So we have a couple more webinars coming up in the next month. October 17th is our third Thursday. It's tips from Bar Counsel. So Bar Counsel is going to be here from 12 to 1 on that day to talk about Bar Council things that should be interesting. And then November 6th, we're actually doing a foreclosure basics training. This is going to be an in-person training. It's going to be here in our office building on the 3rd floor from 9 to 3:30. Lunch will be provided. So this is going to be a very basic training. So if you have never done any kind of foreclosure work and you're interested, please come. It'll cover everything from just the basics of mortgage servicing and lending, all the way to how to handle foreclosure mediation and what to do after foreclosure mediation happens. And then you can see the other two, Circular 230 on November 12th, that's actually a tax webinar. And then November 21st, we're going to do another third Thursday webinar on service of process. If you go to our website, you can register for those. And if you have any questions about those, you can always email me, or you can send an email to the contact for each of those trainings, which should be on the website. Okay, any other closing thoughts, Debbie?
No, again, I think that when you're in the district court, the rules are your friends. Really spend some time reading the rules, because they're different from what you're taught in law school. You're taught the rules in the circuit courts. The district court rules are different. The judges know them, and if nothing else, you save yourself some embarrassment when the judge says, have you read rule such and such? So read the rules.
All right. Okay, thank you everyone for coming today. And like I said, we'll send out an email to all the attendees with all the attachments again. So if you didn't have one, you will get it. And I believe that you're all also going to get an email or a notification just asking you to fill out a survey after the webinar is over. So just ask you to fill that out, let us know how we did, and give us any suggestions for future webinars. Thanks for coming, and have a great week.